Some may see Friday the 13th as unlucky, but maybe it's my lucky day. I don't know. It's my last day here on WMAY, and I want to thank everybody for the years and years and years of you having to put up with my voice over these airwaves, either on the AM station when we were just 970 AM to when it was 94.7 FM and WMAY on the AM, but now we're at 92.7 FM, and I've seen quite a bit of evolution in the radio industry in just a handful of years, quite frankly. Bit my teeth here on talk radio way back in 2006. Just thinking about that blows me away. We'll talk about all of that a little bit later on, I promise. I'll elaborate more on my history here, fill some of you in who've just started tuning in the past year of what's going on, and let you guys know that I'm still going to be producing news content. I'm still going to be producing talk news information. So if you subscribe to me on YouTube, if you follow me on X, formerly known as Twitter, or if you see me on Facebook, you'll still be able to get that content on a regular basis. All right? So just so you guys know, I'm just not going to be coming into the radio station to perform a 3-hour show, which I tell you, as a part-time gig, it really is, quite frankly, a full-time gig, practically, because, ask my wife. I'm sitting there scheduling interviews while we're either at dinner or while I'm laying in bed, so that's obviously something that is going to be cut down quite a bit because I don't have to fill 3 hours worth. So we'll talk about a lot of that, all right? I promise, and we'll open up phone calls as well for you to chime in and share your thoughts. 217-629-7970. It's Springfield's Morning News on WMAY, but let's go ahead and jump into what we've got coming up here with the latest in litigation against gun laws. And you've got the Seventh Circuit U.S. Court of Appeals still having the Second Amendment case that was argued back in late June from the Southern District and Northern District cases combined into the Seventh Circuit. So we talked about how earlier this month, the plaintiffs, they filed a third note of additional authority that they say the Seventh Circuit needs to look at. If you recall, the plaintiffs already said, look at Hawaii's ruling that says banning butterfly knives is unconstitutional. Look at a different ruling out of California that deals with the magazine bans there. And then there was also a third one that they asked recently, earlier this month, to look at the pistol brace ruling out of Texas that said pistol braces and the rule is unconstitutional. So all of those things over in different court jurisdictions are being dealt with, but the plaintiffs here in Illinois are asking the Seventh Circuit to review exactly that. What is the other cases and how they should impact Illinois. But yesterday, in the Seventh Circuit U.S. Court of Appeals, the state did indeed file a response to at least one of those three. They've already responded to two of them. The third one, the pistol brace rule, I haven't seen that response quite yet, but they did provide an update on the California mag ban case, where a district court in California said that magazine capacity limits are unconstitutional, then put a stay on that while it went up to the Ninth Circuit. And you've probably heard about some of what people say is some trickery going on with the Ninth Circuit, doing an en banc panel instead of a 3-judge panel there. But the Illinois State Police and the state of Illinois filing yesterday in the Seventh Circuit pointing to what's going on over in California. And here's what they had to say. They said, in the case Duncan v. Bonta, plaintiffs cited as supplemental authority. They go on to say that an en banc panel of the Ninth Circuit subsequently granted an administrative stay on the district court's decision while the parties completed briefing on the California Attorney General's motion to stay pending appeal. October 10th, state police say the en banc panel over in California and the Attorney General's motion for an emergency stay entered a stay on the district court's order while the appeal is pending. The court concluded that the California Attorney General, quote, is likely to succeed on the merits. And the merits of the law, they say, is to restrict the possession of firearm magazines over 10 rounds of ammunition, saying that arguing it comports with the Second Amendment under the U.S. Constitution and the Supreme Court's ruling in Bruin v. New York State Rifle and Pistol Association. So that's the latest from the Seventh Circuit U.S. Court of Appeals. Still no ruling, still no outcome of how the 3-judge panel there is going to rule on Illinois' gun and magazine ban. But yesterday they did have a filing from state police essentially simply saying, hey, I know the plaintiffs are looking at this magazine ban over in California, but there's a stay that's been put on that. Another thing that we want to look at, of course, is the latest with the hearing that we had earlier this week down in East St. Louis, where Judge Stephen McGlynn heard the vagueness challenge against the state's gun and magazine ban. So during that hearing, it was noted by the judge that the state filed late Tuesday evening 400 pages of documents, witness testimony and affidavits and things along those lines. But the plaintiffs hadn't had a chance to review it, so they said, we'll take 7 days to review all of that, and ultimately the judge kind of reset a deadline. So don't expect a ruling out of the MAG case here in Illinois down in the Southern District, at least until October 18th. After October 18th, that gives that 7-day window for them to review the state's late-minute filings. So you've got that to contend with. And then you've also got the transcript that's being ordered. So yesterday they did say that they're going to prepare that transcript. So you won't have to rely on my tweet storm from when I was practically the only media in the courtroom covering that case. But I did want to cover something here really quick. You remember this clip from earlier this week? It was from over the weekend last week where Voodoo Gun Sales highlighted how they are tracking now the sale of ammunition. And not just the sale of ammunition in Illinois, they're also tracking what caliber of ammunition. If you recall, remember this?
And then I clicked on the select ammunition transfer, and then this now comes up. This is brand new. So they're now tracking the caliber of the ammunition that you're buying.
And why would they do that, Joe?
The only reason I can think of that they would want to track the ammunition that you're buying is because if you're not going to register your firearm, but you buy 223, it's going to be pretty obvious that you're buying 223 for an AR, and they're going to want to know why you're buying ammunition for a gun you didn't register. So think wisely, my friends. Figure out how you're going to do it, because they're coming.
So again, the warning there that they're tracking ammo sales, but not just ammo sales. They're also tracking the ongoing caliber size for those ammo sales. The judge apparently either saw that video or just had that his own idea that could be possible, because during the hearing, if you watched my tweets, you'll be able to see that the judge asked the state about warrants based upon ammo purchases if police say such persons haven't registered guns. Wells said that is a facial challenge not applied, and that's the state's attorney there, Christopher Wells. It's a facial challenge not as applied, said not sure if such example would trigger a warrant. So that was interesting to hear the judge, Stephen McGlynn, make that question for the state to respond to. So that's the latest out of course, the MAG case. But you've also got another case here that we've been tracking, and that's the gun industry liability case, where the latest there, you have the state yesterday filing a notice of an attorney to appear the day before that. There was an order granted saying for good cause shown, defendant's unopposed motion for leave to file over lengthy briefs is granted. So they originally, back last in September, they asked for a delay in responding to the plaintiff's motion for preliminary injunction on the gun industry liability case here in Illinois. So they've got that now pushed to October 19th, which is coming up in just a handful of days. And we'll be covering this. If you follow me on YouTube, we will be continuing to cover these stories. So be sure to hit like and subscribe and all that if you're watching online. But they did delay and say, yeah, we're granting an order for delaying. October 19th when they have to do that. But now an order says for good cause shown, defendant's unopposed motion for leave to file over-length brief granted. Defendants may file a brief limited to 40 pages in length in response to plaintiff's motion for preliminary injunction, and that's signed by the Judge Stacey Yandel. So that was earlier this week in the gun lawsuit liability case. Something else, too, just looking at elsewhere throughout the country, here's a headline. You've got New Mexico's ban on carrying guns in parks upheld by a judge. And that's a sensitive places concern, which obviously, we'll see how that case transpires throughout the appeals courts as well. So that's just an overview of at least where we're at with some of the more high-profile cases, including cases here in Illinois when it comes to gun legislation.